Sir, I need you to step out of the vehicle right now.
Deputy, I want you to look at what I'm wearing. I want you to look very carefully.
Sir, I'm not going to ask you again.
My name is Marcus Caldwell. I'm a United States Federal District Court judge. And every second of this time is being recorded.
At exactly 9:22 p.m. on a rain-soaked Thursday evening on Interstate 95 southbound near the Broward Boulevard exit in Fort Lauderdale, Florida, a traffic stop that should have lasted 3 minutes turned into a 26-minute civil rights catastrophe that would eventually cost Broward County $34 million. The dashboard camera footage, the body camera footage, and the courthouse security camera footage would later be combined into a single video that racked up 61 million views across every major platform in less than 10 days. But this was not your typical traffic stop video. This was a sitting United States Federal District Court judge, a man with the power to sentence people to federal prison and hold law enforcement in contempt of court, being pulled to the side of a rain-soaked highway, removed from his vehicle, and treated like a suspect while still wearing his black judicial robe. What happened next would shock the Broward County Sheriff's Office, trigger a federal civil rights investigation, spark a congressional inquiry, and ignite a $34 million lawsuit that proved, in the most uncomfortable way possible, that in America, a badge and a black face can still collide in ways that no title, no robe, and no achievement can fully protect you from. Before we continue, drop a comment and tell me where you are watching from. And if you have not subscribed yet, hit that button now because this story does not get less intense. It gets worse before it gets better, and you need to see where it ends. Judge Marcus Anthony Caldwell was not your average 44-year-old man. Born and raised in Liberty City, one of Miami's most historically underserved neighborhoods, Marcus grew up watching his mother work double shifts as a hospital orderly and his father drive a city bus 6 days a week. Neither of them had graduated college. Both told Marcus every single day that education was the one thing no one could ever take from him. He listened. He graduated valedictorian from Miami Northwestern Senior High School, earned a full scholarship to the University of Florida, graduated summa cum laude, then attended Yale Law School where he served on the Yale Law Journal and graduated in the top 5% of his class. He clerked for a United States Circuit Court judge, spent a decade as a federal prosecutor with the Department of Justice, and at 39 years old was nominated by the President and confirmed by the Senate as a United States District Court judge for the Southern District of Florida, one of the youngest sitting federal judges in the state at the time of his confirmation. He had presided over hundreds of cases. He had sentenced cartel leaders, corrupt politicians, and financial criminals. He drove a black Mercedes sedan with current registration, active insurance, and a federal vehicle placard on his dashboard. And on the evening of October 14th, he was driving home from the federal courthouse in downtown Miami, still wearing his judicial robe, because a particularly grueling hearing had run nearly 2 hours past schedule. He was tired. He was hungry. He was 11 miles from home. And he was about to have the worst 26 minutes of his adult life. The rain had started during the hearing. By the time Caldwell merged onto I-95, it was coming down steadily. That flat, persistent Florida rain that turns the highway into a river of red taillights and makes everything feel heavier than it is. His dashboard camera, recording continuously, would later confirm he was traveling at 67 miles per hour in a 65 zone. He was in the center lane, not swerving, not on his phone, hands on the wheel, eyes on the road, a legal affairs podcast playing softly through the speakers. Because even at 9 o'clock at night after a full day on the bench, Marcus Caldwell was still listening to legal content. He had been stopped before, not many times. But enough. Enough to know the particular way the shoulders tighten when you see blue lights in the mirror, and you know you did absolutely nothing wrong. He saw those lights at 9:22 p.m. He signaled, pulled smoothly onto the shoulder, placed both hands on the steering wheel, turned off the podcast, and pressed the backup audio record button on his dash cam. His heart did not race with panic. It raced with cold, practiced awareness. The awareness of a man who knew every word of the Fourth Amendment from memory and understood exactly what his rights were. Then he waited. The deputy who approached that evening was Brandon Kowalski, an 8-year veteran of the Broward County Sheriff's Office Highway Patrol Unit. He had a serviceable record, 2 commendations, 1 prior internal complaint for verbal aggression that had been closed with a notation of counseling. He had made thousands of highway stops. He operated on routine, on the assumption that civilians did not push back. Kowalski approached the driver's side window with his flashlight up. He could see the briefcase on the passenger seat. He could see, draped over the back headrest, a long, black robe. He did not register what that robe meant. He tapped the window with 2 knuckles. The window came down. Deputy Brandon Kowalski looked at the face of a United States federal district court judge and saw only a black man in a nice car on a rainy highway at 9 o'clock at night. He said in the flat tone of a man running a routine he had performed 1,000 times. License and registration. Judge Caldwell reached slowly into his breast pocket and produced his federal judicial identification card first. The gold-embossed card issued by the Administrative Office of the United States Courts, identifying him by name, title, court, and photograph. He placed it on the window ledge alongside his driver's license and registration. "My name is Judge Marcus A. Caldwell," he said, his voice even and unhurried. "I am a United States Federal District Court judge for the Southern District of Florida. My registration is current. My insurance is active. I would like to know the specific reason for this stop." Kowalski picked up the driver's license. He did not pick up the judicial ID card. He shone his flashlight briefly at the robe on the back seat, then back at Caldwell's face. "Sir, I clocked you traveling at 78 miles per hour. Caldwell paused for exactly 1 second. "Deputy, I was traveling at 67 miles per hour. My dashboard camera has been recording continuously since I left the courthouse. I was not traveling at 78 miles per hour. Kowalski walked back to his cruiser, and that is when things began to go seriously, irreversibly wrong. Kowalski was back at the window in under 3 minutes. His tone had changed. "Sir, I'm going to need you to step out of the vehicle." Caldwell did not move immediately. "Deputy, am I being detained? And if so, for what specific reason?" "Sir, step out of the vehicle." "I heard your request," Caldwell said. "I am asking you to provide me with the legal basis. Under Rodriguez versus United States, you cannot extend this stop beyond its original purpose without new articulable reasonable suspicion. You ran my plates. My registration is current. My license is valid. What is the basis for asking me to exit the vehicle?" In 8 years of highway patrol, no driver had ever cited Rodriguez versus United States at a traffic stop. Not once. Kowalski's jaw tightened. "Sir, I am asking you for the last time. Step out of the vehicle or I will remove you." The body cam footage captures this moment in full. You can watch Kowalski make the decision that would cost Broward County $34 million. You can see it in his posture, the slight forward lean, the hand moving to the door handle. "Deputy," Judge Caldwell said, his voice still perfectly measured, "I want you to understand something before you take any further action. I am a sitting United States Federal District Court judge. I have federal judicial identification on this window ledge. I have a federal vehicle placard on this dashboard. I am wearing a judicial robe. Everything happening right now is being recorded on my dash cam with audio, and your body camera is also recording. I am not resisting. I am simply asking you to state the lawful basis for your request. If you have one, I will comply immediately." 6 seconds of silence. 6 seconds captured on 2 cameras. Then Kowalski opened the car door. "Get out of the vehicle, sir. Now." What happened in the next 4 minutes is difficult to watch even in description. Judge Marcus Caldwell, United States Federal District Court judge, a man who had spent his entire professional life in service to the law, was physically directed out of his vehicle by a Broward County Sheriff's deputy on the shoulder of I-95 in the rain. He did not resist. He complied. He stepped out of the vehicle, his judicial robe catching the wind and rain, his hands raised and visible, his voice steady, as he said for the camera and for the record, "I am complying under protest. I am not resisting. I am complying under protest." Kowalski directed him to the rear of the vehicle and told him to place his hands on the trunk. He did. The body cam shows him standing in the rain, in his black judicial robe, hands flat on the trunk of his own car, while Kowalski patted him down. A United States Federal District Court judge, patted down on the side of a Florida highway, in the rain, in his robes. Kowalski then told him to sit in the back of the patrol vehicle while he completed his investigation. "What investigation?" Caldwell asked calmly. "You have run my plates. My registration is current. I have provided my license. I have provided my federal judicial identification. What investigation requires me to sit in the back of a police vehicle?" Kowalski did not answer. Caldwell, with a quiet dignity that the body cam captured entirely, sat down in the back of the cruiser, folded his hands in his lap, looked straight ahead, and waited. He waited 17 minutes. 17 minutes in the back of that cruiser, in the rain, while passing cars slowed to look. While at least 2 motorists pulled out their phones and recorded from their own vehicles, while Kowalski sat in the front seat, running checks that had already come back clean. And here is where the investigation would later uncover something that made this case even more serious. The body cam audio captured Kowalski making a phone call during those 17 minutes. His side of the conversation was recorded. He could be heard saying, and I am quoting directly from the investigation report, Yeah, I got some guy in the back claiming he's a federal judge. I think he's full of it, robe and everything. Probably stole the car. He laughed. Then he said, just running it out. His plates came back clean, but I want to make sure before I let him go. The plates had come back clean on the first run, 4 minutes into the stop. Kowalski kept a sitting federal judge in the back of his cruiser for another 13 minutes after the plates cleared because he thought the man was, in his words, full of it. Then a second Broward County cruiser arrived. Senior Deputy Sergeant Patricia Ware got out, walked to the Mercedes, saw the gold-embossed federal judicial ID card still sitting on the rain-wet window ledge, recognized it immediately, and walked very quickly to Kowalski's window. What was said between them was not captured on camera, but within 90 seconds, the rear door of the cruiser was opened. "Sir," Sergeant Ware said, "you are free to go. I apologize for the delay." Judge Marcus Caldwell stepped out of the back of the police cruiser. He straightened his judicial robe. He walked back to his car. He picked his federal judicial identification card up off the rain-soaked window ledge. He placed it back in his breast pocket. He looked at neither deputy. He got in his car. He drove home. And the moment he walked through his front door, before he changed out of his wet robe, before he ate dinner, he called his attorney. Quick question for you watching right now. If you had been driving past on that highway and saw a man in a judicial robe being placed in the back of a police cruiser, would you have stopped? Would you have recorded it? Drop your answer in the comments. Most people who have a bad traffic stop experience might vent on social media, call the department, get passed around on hold for an hour, and eventually give up because the system feels impossible to fight from the outside. Judge Marcus Caldwell was not most people. He had spent his entire career inside that system. He knew exactly which mechanisms existed to hold law enforcement accountable, and exactly which federal statutes applied to what had happened on that highway. What he filed the following Monday morning was not a complaint. It was a 41-page federal civil rights lawsuit. Filed in the United States District Court for the Southern District of Florida, the lawsuit named Deputy Kowalski personally, the Broward County Sheriff's Office, and the Broward County Board of County Commissioners as defendants. It alleged violation of the Fourth Amendment, unlawful seizure, without reasonable articulable suspicion. It alleged violation of the 14th Amendment, equal protection, with racial discrimination, claims supported by a statistical analysis of Kowalski's prior stop data. It alleged violation of 42 U.S. Code Section 1983. It alleged intentional infliction of emotional distress. And it demanded $34 million in damages. The lawsuit was accompanied by the full, unedited dash cam footage, the full body cam footage obtained through a federal records request, DOT highway camera footage, and sworn declarations from 2 motorists who had recorded from their own vehicles. The Broward County Sheriff's Office received that lawsuit on a Monday morning. By Wednesday, the sheriff had called an emergency briefing. The investigation was assigned to Lieutenant Donna Reyes, a 20-year veteran who had previously worked in the Civil Litigation Division. She watched the body cam footage once all the way through. Then she watched it again. Then she pulled Kowalski's dash cam footage, the DOT highway footage, and placed Kowalski's written incident report next to the recording's timestamp by timestamp. The discrepancies were significant and immediate. Kowalski's report stated he observed the vehicle traveling at 78 miles per hour. The DOT footage showed Caldwell moving consistently with surrounding traffic. Caldwell's dash cam recorded GPS-confirmed speed data of 67 miles per hour, and Kowalski's own cruiser dash cam, capturing the approach sequence, showed no radar gun activation prior to the stop, meaning there was no electronic record of the 78-mile-per-hour reading he had reported. Kowalski's report did not mention the federal judicial identification card. It described Caldwell as an uncooperative motorist who refused to comply with lawful orders. The body cam showed a man who had calmly and repeatedly asked for the legal basis of the stop while remaining completely non-threatening and physically still. Then Reyes pulled Kowalski's full stop history for the previous 24 months out of his last 217 documented traffic stops on the I-95 corridor. 161, 74%, involved black or Latino drivers. Stops of white drivers on the same stretch averaged 4 minutes and 12 seconds. Stops of black drivers averaged 11 minutes and 47 seconds. No one had ever compiled that data before. No one had ever looked. The investigation was concluded in 19 days. Everything was documented. Everything was on camera. Everything was undeniable. The official findings stated that Kowalski had conducted a stop without sufficient documented evidence of a violation, extended the stop without new articulable suspicion in violation of established federal case law, filed an incident report containing material inaccuracies contradicted by multiple independent video records, and that his recorded phone communication raised serious concerns about the motivations underlying the stop and the detention. The findings recommended termination. Deputy Brandon Kowalski was terminated from the Broward County Sheriff's Office. His 8-year career ended because of a 26-minute encounter with a man he had decided in an instant did not belong in the car he was driving. The Broward County legal team contacted Caldwell's attorneys within 30 days of the lawsuit being filed. They had watched the footage. They had read the 41-page complaint. They had seen the statistical analysis. And they understood that putting any of this in front of a jury, especially with that phone call audio, especially with those stop numbers, especially with the image of a federal judge in his robe sitting in the back of a sheriff's cruiser, would be catastrophic. Negotiations lasted 62 days. Broward County agreed to a settlement of $34 million. $22 million went directly to Judge Caldwell as compensatory and punitive damages, one of the largest individual civil rights settlements involving a traffic stop in Florida's recorded history. $8 million was designated as a mandatory civil rights training and reform fund controlled by an independent oversight board. $4 million was directed to establish a community legal education program in Liberty City, Judge Caldwell's childhood neighborhood, providing free legal rights education to residents specifically around their rights during police encounters. Judge Caldwell did not attend the settlement press conference. He released a single written statement. He wrote, "I did not pursue this case because of what happened to me. I pursued it because of what happens every day to people who do not have a federal judicial ID card, who do not know the case law, who do not have the resources to fight back, and who spend the rest of their lives carrying what happened on the side of that road. The settlement is not justice. It is a start. Justice would be a system in which none of this would have happened in the first place." Do you think $34 million was enough, or should it have gone further? Drop your honest answer in the comments. When the footage hit the internet, it did not trickle. It erupted. The Broward County Sheriff's Office had initially declined to release any footage citing the personnel investigation. Caldwell's legal team filed a public records challenge within 72 hours. The footage was released under court order 8 days after the stop. Within 48 hours, it had been viewed 30 million times. Within 72 hours, it was covered by every major American news network, every major newspaper, and media outlets in 17 countries. Law school professors assigned it as required viewing. A sitting United States Senator called for a congressional hearing on stop patterns in Florida. The Florida ACLU filed a separate civil rights complaint with the Department of Justice. After the footage went viral, 4 other drivers came forward with complaints about Kowalski specifically. 3 described nearly identical encounters: a vague stop justification, pressure to consent to a search, extended detention while checks that had already cleared were rerun. All 4 complainants were black men. None of them had known they could refuse the search. All 4 searches had found nothing. All 4 prior complaints had been filed with the sheriff's office and dismissed. After the settlement, the department reopened all 4 files. This raises the question that sits over this entire story and never fully goes away. How many stops like this happened before Marcus Caldwell? How many people sat in the back of a police cruiser, innocent of everything, and went home in silence because fighting back felt impossible? We do not know. And that is exactly the problem. The Broward County Sheriff's Office announced mandatory policy changes within 90 days of the settlement. Every highway patrol deputy was required to complete a 16-hour refresher course on Fourth Amendment compliance, specifically the Rodriguez Standard governing stop extensions and lawful basis requirements for vehicle exit orders. A new stop data reporting system required deputies to record the specific articulable basis for every stop and detention in real time, vocalized on body camera. A quarterly demographic stop audit was implemented, conducted by an independent review board, and the use of the nothing to hide framing, telling a driver that declining a search meant they were hiding something, was formally prohibited and removed from every training document in the department. Essentially, the Broward County Sheriff's Office spent the better part of a year building the kind of training program that Judge Marcus Caldwell could have designed in his sleep. As of the time this story was produced, Judge Marcus Caldwell has returned to the federal bench. He established the Caldwell Civil Rights Fellowship at the University of Florida, funding 2 law students per year to complete civil rights internships focused on police accountability litigation. He testified before the Florida State Senate Judiciary Committee on stop and frisk data collection reform, and he published a widely read essay in the Yale Law Journal titled "The Robe and the Road: What a Traffic Stop Taught Me About the Distance Between the Law and the the page and the law on the street. In every interview since the settlement, he has said the same thing. He does not consider himself a hero. He considers himself a man who had advantages he did not earn on the side of that highway. Advantages that protected him in ways they do not protect everyone. Deputy Brandon Kowalski is no longer in law enforcement. Here is the question I want you to sit with. If you had been in Judge Caldwell's position, stopped, questioned, removed from your car in the rain, placed in the back of a cruiser, knowing everything he knew and knowing you had done nothing wrong, what would you have done? Think about it honestly. Drop your answer below. Let's talk about the bigger picture. Because this story is not really about one deputy and one judge on one rainy Florida highway. It is about three things that are much larger than that. It is about the distance between rights on paper and rights in practice. The Fourth Amendment is not abstract. It governs what law enforcement can and cannot do to a human being on the side of the road. But rights on paper mean almost nothing if neither person at that car window knows them. The law only protects you when you can invoke it, and you can only invoke it when you know it. It is about what happens when authority goes unchecked by knowledge. Kowalski operated for 8 years on the assumption that the people he stopped would not push back, would not know the case law, and would not have the resources to hold him accountable. For most of those 8 years, he was right. The data proved it. The pattern existed long before October 14th. It just had never been confronted by someone who had both the knowledge and the tools to make the confrontation matter. And it is about the cost of silence. Every person who sat in the back of Kowalski's cruiser before Caldwell, every person who consented to a search they could have refused, every person who went home saying nothing, their silence was not failure. It was a rational response to a system that made fighting back feel dangerous and impossible. Judge Caldwell's advantage was not just that he knew the law, it was that he had the standing and the resources to use what he knew without the same catastrophic risk. Most people do not have that, and some of those who try to assert their rights without those protections do not make it home. The badge does not automatically make you right. Knowledge is the most powerful equalizer a civilian can carry, not because it guarantees safety, it does not, but because it creates accountability. And accountability, over time, is how systems change. So what do we actually take away from this story? First, document everything, always. A dash cam, a phone recording, your own voice stating timestamps out loud. These are not signs of paranoia. They are the difference between your account of events and the version that ends up in the official report. Judge Caldwell had 3 independent recordings. That is why the case was unwinnable for Broward County before it ever reached a courtroom. Second, you have the right to know the reason for your stop. An officer must have reasonable, articulable suspicion and must be able to state it. You are permitted to ask, calmly, clearly. You do not have to accept a vague answer. Third, you do not have to consent to a search. This is not a trick. It is a constitutional right. You can be cooperative in every other way and still say, I do not consent to a search. The absence of consent cannot be used as evidence of guilt. Fourth, know the difference between compliance and silence. Stay calm, stay physically cooperative, follow lawful orders. But invoking your rights, asking for legal basis, and creating a verbal record is not confrontation. It is citizenship. Fifth, use the accountability system. File complaints, request footage. Find a civil rights attorney if you can. Not every story ends in a settlement, but every documented complaint creates a record. And records are how patterns get discovered and how careers like Kowalski's eventually end. One man, one rainy highway, 26 minutes. And a department that had been running the same pattern for years was finally forced to face what it had been doing. That is the power of documentation. That is the importance of knowledge. That is what happens when a person who has been told their whole life that the law belongs to everyone actually holds it in their hands and refuses to let go. Final question. What is one thing you learned from this story that you did not know before you started watching? Drop it in the comments. And if this story moved you, share it, because someone in your life needs to hear it. This story matters not just because of what happened to one judge on one night on one Florida highway. It matters because of every person who was stopped before him and had no credentials to show. It matters because of every complaint that was filed and dismissed. It matters because of every search consented to out of fear rather than knowledge. It matters because somewhere tonight on a highway in this country, there is a person being asked questions they do not know they are not required to answer. And they are doing it in silence because no one ever told them otherwise. Judge Caldwell's legacy is not $34 million. It is this: the possibility that someone watching this video tonight will know something tomorrow they did not know today, and that when their moment comes, they will be ready, not with anger, not with confrontation, but with knowledge, with documentation, with their hands visible and their voice steady and their rights intact, because that is what the law was always supposed to be, and that is what it becomes when we refuse to let anyone take it away.